be kept secret in federal court.
Thank you.
Thank you, counsel. Justice Thomas? Justice Alito?
I don't know that we've ever invoked Schroinger's cat in our analysis of statutes or rules, but what are you saying? Is the affidavit of merit a pleading for purposes that we've got Rule 8 and Rule 11? Is it a pleading for one and not a pleading for the other?
So the way that the statute is described in various places is either as it doesn't have any impact on the case. It's not evidence that's used at the trial. In fact, it has to stay secret. The defendants never get to see it, so they can't even use it tactically in the case. In which case, how is it evidence? It's just a procedural barrier. You have to just give the papers to the judge, and that's it, and then it's out of the case. And if that's true, then we do think that that makes it basically functionally a pleading. It's basically give us some secret allegations.
Under both rules, it's a pleading.
Say it again. I apologize.
Under both Rule 8 and Rule 11, it's a pleading.
We would say it's a pleading rule. So Rules 8 and 9 set forth the pleading rules in federal court, and it functionally acts like a pleading by creating more allegations. Imagine it wasn't the doctor who had to submit the AOM. Imagine you had to submit extra, particularity evidence to plead a case. All they've done is make the particularity requirement. They've assigned it to some other person who has to come in and substantiate your case. So in that
on the facts of this case, so your client hurt his foot. He was treated by a doctor in Delaware. Presumably, he got a report what the doctor did. Goes home to Florida. Maybe he sees another doctor. What discovery do you need?
Well, I think the most telling discovery could simply be asking the individuals at the facility where, so he alleges that when they were fitting him with medical equipment, they actually caused the injury. Individuals at the doctor's office caused the injury. Deposing them or deposing people who work with them could be helpful. Looking for contemporaneous communications. All these things are permitted, and in fact, they're the purpose of Rule 26. And so if you have, people sending messages to each other that say, like, we really need to change the policy where we just put this on people's feet, because it's probably malpractice, that would then inform another medical professional's ability to render an expert.
Could the district court grant summary judgment before allowing all that discovery?
Yes. I mean, under the federal rules of civil procedure, you would have to put in your 56D and say, this is what I need and this is why I need it, and the judge has a great deal of discretion in determining whether to.
Justice Sotomayor?